We're going to talk about loan modification options. There are many of them, but the one that we're mostly talking about these days is HAMP. So we're going to spend a lot of time on HAMP. Dove is going to take you through the provisions of HAMP, especially as it relates to legal issues, because HAMP gives us some legal hooks for helping people stay out of foreclosure and defend foreclosure if they get into foreclosure. And then we're going to come back to Jennifer to talk about other alternatives. And we'd like to entertain as many questions as possible, so ask them when you have them. We'll also try to leave time at the end.
Okay, thank you. So to give you an extremely brief overview, and then we, as Beth said, we'll come back at the end. The biggest modification program out there right now is HAMP. Over 75% of the mortgages in this country are covered by HAMP. That's why we're so gung-ho about it, and Dovie will get you all the details about that.
Let me just take a look at the first page of the materials that has what sort of an outline of what Jennifer's talking about.
But in addition to HAMP, there are a lot of other programs out there. There's a partner to HAMP called HARP, and the R stands for refinance instead of modification. And that's a companion that goes along with the HAMP program. There are also the state-specific programs, which include HEMAP and HERO and REAL. HERO and REAL are both refinance programs, and HEMAP is the rescue loan program. There are also programs specific to other government loans that are already out there. FHA loans, HUD loans, VA loans. They have specific loss mitigation rights and specific programs to help people there. And lastly, there are a lot of other lender programs besides just the HAMP program. Even HAMP participating lenders have alternative programs available. And one of the really great resource guides out there, it's letter B under number 5, which is the NCLC website. And they have this phenomenal chart that is every lender's loan modification programs and all the guidelines to go with it. So if you're ever at a loss to try and find another way to help a client, that's the first place I think you should go and just see what's out there for your client. With that, I think we'll go back to learning about HAMP.
Did everybody see where this is on the handout, Jennifer?
Do you have any additional details?
Yeah, Don has them.
Okay, so there's been a lot of anticipation to get into the HAMP material, and here we are. So basically, I'm just going to jump into the details of the HAMP modifications for first lien mortgages first, and then if we have time, there are two more recent programs that were just rolled out over the last couple months. One is the second mortgage program through HAMP, which is a different program, has a lot of similarities, and obviously pertains just to second mortgages. And then finally, the FHA HAMP, which is for FHA loans. Also similar, but some significant differences. So HAMP is, as you see here, is the Home Affordable Modification Program, often referred to as the Obama Plan. It offers streamlined loan modifications for eligible homeowners, and as Jennifer said, more than 3/4 of all mortgages, and I think that number is constantly rising, fall under it. And when you don't know, which is usually on many loans, you know the big ones, but after a while you keep on coming in contact with servicers you haven't heard of before. You can check the website, which is in the materials that you have a few pages in from the front. Sources of information. There are several websites there that are very helpful. On the second page of those materials, there's the website for the actual servicer agreements, and the website where you can find all the participating servicers. So it always pays to go and make sure that the servicer is signatory to the program.
Right. HAMP, in the end, is a contractual agreement between the servicer and the Treasury. I mean, actually, Fannie Mae is the entity that's the counterparty in the agreement. So you have an agreement with lots of requirements that are pulled into it by directives and questions and answers that are on these websites that Dovie mentioned.
The program pertains to loans that were originated before 2009, but the program as of now will stay in existence at least through 2012. So any loan that was a first lien mortgage that was originated before 2009, and you check the servicer and you see that the servicer is a participant, they've signed that contract, then the following information pertains to them. Let's see. Which loans are eligible? As I was just saying, first position mortgages held by Fannie or Freddie or serviced by participants are eligible. Now, in addition to that, the FHA loans are also eligible. That's the website that you have in your materials where you can check the specific servicers to see if a loan is a Fannie Mae loan. That's where you check Freddie Mac. This is an issue that you often see. Some servicers will tell homeowners will not really know anything about HAMP, but they'll know about the Obama plan or more broadly about a modification. And the servicers, people on the phone, will tell them, no, we don't do that. Now, some of that was due to the fact that this is all kind of new stuff. As of April and May of last year, it was very new, and now less new. So now at this point, if servicers who are participating are telling clients or people you're talking to that they're not participating, that's a problem. And a lot of it is just, it seems to be a tactic that they use to kind of weed some people out. And sometimes it's just ignorance of the person on the phone, but it's definitely something to not take at face value. The way to do it is to check the website and see who's a participant. Which homeowners are eligible? There's a website where you can find the eligibility criteria, but basically it's not too complex. The housing costs have to be more than 31% of gross income. What that means is that you basically just take the current mortgage payment before any modification consideration over the total income. And if that number is over 31%, then they're probably eligible for the plan. We were talking about this earlier, the grossing up of income for Social Security and other government benefits that are not taxed. That's something that most services are doing, although what's your position? I know it's a little
I'm
bit
going to
different.
take slight exception to our own slide. Where you come down on this issue depends on what you're trying to get for your client. I've recently had a case where the mortgage servicer grossed up my client's SSI income, which put her $2 over the 31%. In other words, the mortgage payment was now already less than 31% of her grossed up SSI income. So I went back and took a look at the supplemental directive on HAMP. And the way the text reads is that gross income includes Social Security and disability income. Then it says if the servicer doesn't have access to the gross income, you can gross up the net income by 25%. So in that case, I needed the client's income to not be grossed up in order to be eligible for HAMP. Because again, if your mortgage payment is already less than 31% of your gross income, you're not eligible. So upon that reading, I believe that they're not supposed to be grossing up Social Security and disability and other public benefits in order to figure out if the person's eligible for HAMP based on the percent that their housing cost takes of their income.
And this issue of, go ahead.
Can I also mention, I know one lawyer who takes the position that if the mortgage payment is currently below 31% of gross income, making you ineligible, but if you're on some kind of forbearance plan or have been offered some kind of forbearance plan and the payments you would have to make on that might bring you over 31% of your gross income, then you make the argument that that's what your housing costs are. I have no idea whether that's succeeded anywhere, but it seems plausible.
Yeah, and your first goal regarding all this material is to get familiar with the basics, and then when you're looking at cases one at a time, figure out how the case fits into it. But again, I think that the grossing up should not be happening for the initial eligibility determination.
And this issue of the level of income is something that, as practitioners who are dealing with these modifications and trial payment plans that we'll deal with, is a big one because you're going to see, we'll talk about it soon, but sometimes you're going to want the income to be higher, sometimes you're going to want it to be lower, and that will kind of affect how you how you put things together. But
And just as another comment on the sources of the rules for HAMP, the contracts that the servicers have signed don't say anything. It says, see the supplemental directives and other sources for the rules of HAMP. So you have to go to these other documents to get the details. The other documents are listed in your handouts. The program guidelines that were issued, the very first document issued on March 4th of 2009, the supplemental directives, the frequently asked questions. You can go to these websites, get those documents, and see the actual text of the requirements for HAMP, but they're not in the contracts.
And you'll see when you read the supplemental directives, you'll see why there are a lot of question marks. The language is never quite as crisp as you want it to be, and the questions are coming up as you're reading it. But and that's why if you're wondering what do you mean, why isn't there an answer? You'll see when you read it. In terms of homeowner eligibility, the homeowner has to be at least 60 days delinquent on the loan, which means has missed 2 months payment, or alternatively, default is reasonably foreseeable, as determined by the servicer. But if the borrower can actually establish that with their income or their changed circumstance, then they too should be eligible for the plan. So in other words, if they can show that default is imminent, they might be current at the time. Technically, they still should be eligible for modification. This is a big problem because a lot of servicers are going to want to see, or acting right now as though you need to be, several months behind before they can even assess this issue. So it comes into play whether you advise a client to, marshal their funds to get current or not, depending on, how you think that might impact their ability to get HAMP. If the servicer is actually not looking at them until, they're 3, 4, 5 months behind, that even though that's not the way it should be, it might come into the calculus of how of the timeline that you're going forward with. It doesn't matter if the client is current or has a sheriff's sale coming up. So again, we'll talk about this soon, but basically once a client is deemed eligible, then the legal status of the foreclosure case, wherever it is supposed to just stand still until the financial situation of the client is assessed by the servicer, and then a determination is made as to whether they're going to be getting a trial period plan and ultimately a modification. So if anything is moving forward while this process is in play, that's inappropriate. And this is a large reason why HAMP is a powerful tool. I know that because it's so new, we really haven't seen that many consummated modifications. It's more, what we know so far is how the process works. And this is a big part of it, to kind of stop the foreclosure proceeding, prevent a sheriff's sale, and kind of buy some more time. That's something that it definitely does do pretty well. This can be pretty important. If the borrower is in bankruptcy, the loan is eligible at the servicer's discretion. So a lot of servicers are saying that as soon as they see there's a bankruptcy, they tell the client they're ineligible. That's definitely not right. They should still be assessed, and they do have to make reasonable efforts to see if a loan modification would work with the bankruptcy proceedings.
Where's their discretion come in? To consider it even though they're in bankruptcy, or just the normal discretion as to whether they're eligible?
I think it's the former, to consider it. But again, that's one of those things that's just kind of fuzzy.
Yeah, I agree that once a servicer has decided to participate in HAMP or has decided that people in bankruptcy will be eligible, the way the program works is formulaic. So they can't decide, yes, I'll consider you, and then say, no, I'm not going to give you HAMP, because you're in bankruptcy.
In terms of the application process, it's never too late to apply as long as the house has not been sold. If the client is eligible, they are eligible to apply, and then things should stop and they should be considered. I've found that the best way to handle it is to put things in writing to the servicer and request it formally, because it's incredible how these new HAMP or loss mitigation units within loss mitigation departments are losing documentation, because this is a lot of paperwork and it's a new program, and they just lose it, and you'll send it 3-4 times. But if you send it in writing, that's the best way to do it. There are multiple ways that it can be done by the servicer. A lot of them will call, they can do it a couple of ways. Well, the way that it works is usually, if a loan is eligible, the homeowner gets a letter in the mail that basically says, you call us on the phone. All you need handy is the loan number and your income information, and we can process it on the phone and give you a trial period plan. Whether or not that they actually do that, that's what the letter says. And if they were to do that, the way that it works is the homeowner can call up, say, I'm making X, here's the loan number, and just with that verbal information, the servicer can send out a trial period plan that has the payment amount of the modification, at least a suspected amount. And then that goes forward for the trial period, which is 3 months. And if those payments are made on time, then the servicer in that 3-month period or at the end can ask the borrower for documentation of the things that person said on the phone. That's tricky because it seems like a really good idea up front just to get the ball rolling, just call them up and get the presumptive modification payments started. But in the end, things get confused on the phone. The client may be understating their income in order to lower their monthly payment. And then in the end, 3 months later, after making that payment or in the middle of that 3-month period, when they send in the documentation and it doesn't jive, the whole thing is going to be taken off the table. So I don't know where other people come down on this, but I think it's better to just up front send the documentation to the servicer and have it be assessed up front. That way you kind of know where you stand.
Could I weigh in there, Dovey?
Sure.
The flip side of this is that the lenders will verbally reject you over the phone after you've told them your income and a few other very small pieces of information. So from my perspective, if I believe somebody is eligible, I want a written, documented application submitted to them, so that way, if I want to litigate the issue later and argue that the denial was improper, I have a full, completed application. Because these verbal applications, I don't believe are sanctioned by the guidelines. The requirement under the guidelines is that you make a written request for this modification, and that's when your rights start to attach. So, and housing counselors, I think, are kind of falling into this trap as well, where they will call up. I mean, part of this is the written applications are not readily available. It's hard to find them. Sometimes they're not even available through the public domain. And so they call up the lender to ask for the application. And the lender says, oh, I can get your information right now and do this over the phone. And they do it, and they're told, I'm sorry, this person's not eligible. Have a good day. And I always kind of want to pull my hair out and say, no, we still want to send in that written application. Let them tell us no after they have it in paper. So I think if you're really serious about setting up these cases and advocating for your clients, you really want to stress that if you're working with housing counselors to make sure, because sometimes they'll say, yes, we applied, but they did the verbal application, and that doesn't get you where you want to be.
The application would be like in a formal letter or is that specific form?
Some lenders have specific forms, like Chase. You can actually find that one if you do Chase HAMP application. You can find it on the internet pretty easily. But other lenders don't have them so accessible. I think if you make a written request to be considered for HAMP and they ignore that and they don't send you the formal application, I think at that point they have a guideline violation. Because when you put in the request, that they then have this duty that Dovey's put up there, they have to consider you and review you. How can they review you if they haven't given you the materials to submit?
I think the only reason that they could say no over the phone is if the amount of gross income you tell them that the current mortgage payment is already less than 31% of that. That should be and you would have figured that out before you called. So really the only reason they should give you over the phone for a no is that one. But otherwise, the program reduces the mortgage payment to 1/3 of the person's income. And that 1/3 includes the principal and interest, taxes, and insurance. Now, whatever the person's income is, you can take 1/3 of it. The person could have $200 a month in income, and there's still a calculation that gives you 1/3 of that. And there are subsequent steps that they will take and that they're allowed to take that is likely to get somebody with such low income turned down. But they can't turn you down because your income is too low over the phone based on that first phone call. They shouldn't be. And as Jennifer was saying, If that happens, you apply anyway. You apply in writing with all the documentation anyway.
And with the exception with your current payment already being less than 31%, like Beth said, there's no reason to be rejected on the phone because all requests must be considered. And the only reason why they wouldn't have to request it is if their servicing agreement that they have with the trust that holds the mortgage, in other words, the investors, prohibits modifications. But even in that case, they're required to make efforts, reasonable efforts, to contact the trust or the investors and get an okay on going ahead with this. Because, like the presenter earlier today was saying, that's an easy out. So there is language in there to prevent that out from being utilized.
And just to add on to that, Dovie, if I may, they are not following that last requirement. They are not going to the investors and asking if they'll waive that requirement. They will, if it pops up on their computer that says investor not participating, they will tell you over the phone, oh, sorry, can't do it. So I think that's really an area that's really ripe for litigation to see if they've really met their duties, because they're not. That we all suspect that they're not talking to the investors and meeting their duties under there.
Right. If the answer the servicer has given you over the phone is the investor won't allow it, don't believe it. That's not usually the case, because as Jennifer just said, they're supposed to check with the investor and ask them for a waiver if there really is something in the agreement that created this trust that now owns the loan. If there really is something in there that prohibits this modification, they're supposed to ask for a waiver. And if I'm litigating a foreclosure, I'm going to ask in discovery. If they've told me, no, you're not eligible for HAMP, I'm going to ask for the documentation. Who called who called the investor, what was who called the trustee, I'm sorry. They never talk to the investor. They don't ever talk to somebody who's an investor. They talk to somebody maybe at the trustee, and that even is probably rare. So you have the right to follow up and demand information.
So like we were saying, no documentation. Was there a question?
Yeah.
Oh, sorry.
I'm sorry. On the last slide, did you say that the application process begins when you send a letter asking to be considered, or when they actually submit a form?
Well, the application process, this is really the next slide, gets into it. The original request can be done over the phone, and I want to be considered for HAMP. A lot of times, the servicers are sending out a standard form that solicits calls and says, call us with your loan number and your income, and we'll get the ball rolling. But when that call is made, they're told, oh no, they're told all kinds of things. But technically, that's all that needs to be done is a phone call. And when that phone call happens, then the servicer has discretion. They can either set up the trial payment period without anything in writing, or they can send out the request for specific pieces of information, and then only when they get that, send out the payment plan amount. Yeah.
To back up a little bit, the contract that the servicer has signed with the government, but it allows them to seek the approval of the investor. So, can you explain that a little bit?
I couldn't tell you if it's in the contract, but it's in the program directives. This program was set up to mirror the process that the servicer should be doing anyway, because most pooling and servicing agreements that created these trusts give the trustee and give the servicer the right to modify loans if it's in the best interest of the investors. And this program really tried to mirror that because it was the only way that the Obama administration could get the servicers to sign on to it. So yes, the investors still have, the trust still has ultimate control.
So how do you explain the investor saying yes in one instance and no in another?
I've never heard of a case where they really said no.
Okay.
So I've heard of cases where we were told that, or counselors were told that over the phone, but if you push at it, it means something different.
So has there been any litigation at all?
I doubt it. I haven't seen any.
Okay.
Do you have any experience with the, say, a lender who is not requiring any documentation? Are they just sort of gaming the system and trying to get their little
No.
incentives, and then they don't do a long-term modification?
Ultimately, there is documentation required, and there's one form at least that has to be signed by every borrower applying for it. It's an affidavit of hardship. that's, you don't have to write a letter explaining why you fell behind. It's just a series of choices, that you check off. And then there are requirements about the documentation of income. So it's not,
Before they make this 3-month trial offer?
Doesn't have to be before.
it doesn't, but
That's what I'm
ultimately,
Right.
asking is, have you found that there are lenders who are just in bad faith saying, we'll do this trial with no real intention of
It doesn't,
making it permanent?
I haven't seen that yet. I mean, you do see problems though, because they often come back with a higher number once they get the documentation. And it's not usually a lot higher, but it can be $100 a month more, something like that. And they haven't necessarily done anything wrong. It's because the borrowers understated their income. But that's why it's better to just get the number up front and figure out what it's going to be.
There have been some reports across the country of lenders who have actually gotten all the documentation, done the trial period, and then changed something later on. And that's been brought to the attention of the Treasury Department, and they are not happy to be hearing that. So they may have gotten it to stop because that was not what this program was intended to be.
Well, I just have a client that came across, and Dan Sullivan actually was doing the counseling for my client, where despite the fact it was a HAMP application, they came back with a 6-month moratorium where they can pay, that's what they're offering right now, 6-month reduced payment, and we'll see what happens later. They did not offer a 3-month trial thing, and I just saw on the listserv that seems to be something that's increasing. Other people are talking about that's what the lenders or the services
Yeah, that's something
are coming back with.
That's something we were going to talk about later, but might as well just do it now. So you get a lot. It's weird because you'll have some servicers who are regularly doing it the right way, and that same servicer will then do it that way, which is to send their typical forbearance agreement paperwork, in which they have, like most forbearance agreements have, the 3 months reduced payment followed by a $30,000 balloon payment due the 4th month. And they'll tell you, they've told me on the phone, oh no, this is HAMP. We just use this paperwork. And it's Wells Fargo, which you have other appropriate paperwork from them, and the person on the phone is telling you this is HAMP. Why would we ever ask them for a balloon payment if we're going to give them HAMP? That just doesn't make any sense. Of course they don't have to pay that. Just have them sign it and send it back in, and that's HAMP. Well, the paperwork says that $30,000 is due, so there's no way. It goes without saying, I would hope, don't listen to that. What I've done is I have sent that back, but only after writing in your own terms above the signature line about what you take this to mean and how this is the wrong paperwork for what it was, represented to you by, the ID number.
Then you have nothing, because you don't have an offer and acceptance there, nothing.
Well, then you'll just deal with it in another month.
I mean, I would say it's not the case that you have nothing. You still have the right to a HAMP modification. And through a series of RESPA requests, and we'll talk about that tomorrow, but written requests that the servicer clear up a dispute that you're having, and that could be probably the best way of dealing with a dispute over HAMP. You could keep pushing to get the right paperwork, while you have your client under this moratorium or a period where they're not pushing foreclosure. But you shouldn't give up if a HAMP modification is the best result for your client, and there may be situations where some other kind of mod that they're offering is actually better for the homeowner than HAMP. And if you've got that, accept it. But if not, keep pushing for HAMP.
Yeah, and that's conceptually, HAMP doesn't put a straitjacket on the servicers. They can do whatever they want to do in terms of modifications that are better than HAMP. It's kind of a floor for eligible loans. So you can always lobby for better terms. You can reject a HAMP, and there are a lot of different ways it can play out. But it's not your only option, and that's important to understand.
Now, I have 2 questions. What happens after 5 years, and also if you have a HAMP agreement after 5 years, and also does your application start for purposes of obligating the foreclosure process to stop? Does the application process start when you call up the fund and say so on the phone that you're applying?
Yes, I think that's pretty clear that it does. And you could even argue that as soon as the servicer has reason to know they're eligible, it starts. This idea of requesting it is not so clear that that's even required. That they have to proactively assess the loans that are eligible. But just to be safe, you want to definitely request it. But in terms of the litigation process, it should stop as soon as that request is made. The first question we'll get to, that's just we'll get into that. So these are the things that are sent either before the trial period begins, or if it were done verbally during the trial period, they'll send out a packet that includes these forms that need to be sent back. They vary depending on the income situation of the client, whether they're receiving benefits, whether they're working, whether they were an heir, that determines what they have to send in, but this is more or less what it is. The hardship affidavit is just confirming that they've had, one of several situations unfold in their lives that justify modification. Pretty much any situation will fit into one item on the rubric. I always type a letter and attach it, just kind of dramatizing the situation and asking for help preventing, me, the client, from becoming homeless, and laying out the situation. You never know, somebody sympathetic might read that and put it into another pile. If there's no reason not to do that, but if nothing else, it makes them feel bad. And this is the language from the regulations regarding the suspension. Any foreclosure action will be temporarily suspended during the trial period or while borrowers are considered for alternative foreclosure prevention options. And then obviously the foreclosure can resume once they've been denied.
By the way, counsel for foreclosure plaintiffs believe that if a foreclosure has already been filed, they can proceed to default judgment while you're waiting to hear about HAMP. We of course think that they're wrong about that, but I find that the safest thing is, if you're able to represent a client while waiting for HAMP, file an answer that at least brings up the potential eligibility for HAMP as a reason to put off default judgment. I mean, you'll want to consider what other defenses that the homeowner may have and not cause those to be waived if you file an answer that only raises HAMP. But allowing a default judgment to be taken while HAMP is being considered seems like a very bad idea.
Can I ask you a question about that? How do you phrase that in the answer? I actually have studied in POs before, kind of an objection that they didn't perform a condition precedent of filing a foreclosure complaint. In an answer, how would you phrase that? As an equitable defense?
Yes, I would. It takes, I think, the same status as failure to comply with FHA servicing, which isn't anywhere in the Pennsylvania Rules of Procedure. Unlike, for example, HEMAP, Act 91 or Act 6, the Pennsylvania courts have recognized that that's a jurisdictional requirement for a foreclosure. This doesn't rise to that level, nor does failure to comply with FHA servicing, but as an equitable defense, you should raise it that way. And by the way, for those of you who've used the Hot Docs foreclosure pleading preparation program that Sheila Fisher has created, you get to it through PA Pro Bono Net. It now includes, and I'm having trouble remembering if it's an answer, if it's part now of the answer for a foreclosure case, or a petition to stop a sheriff's sale because they haven't complied with HAMP. But there are now pleadings available in that program that incorporate HAMP with a lot of good links to it. So if you haven't taken a look at that pleadings preparation program, you can go into the lobby. There are computers, laptops set up out there, and you can take a look at the foreclosure pleading preparation program. The petition to okay. In the back.
You might also raise it as a third-party beneficiary of the contract as another way of
Yep.
getting it.
And I don't think there's anything that says that the homeowner is not a third-party beneficiary to these contracts. I don't think that was made explicit. But even if that argument doesn't work, I think just raising it as the equitable defense to the foreclosure also works.
On your previous slide, you were quoting some language, but I don't know where that quote comes from.
Yeah, that I believe is from the Supplemental Directives 0901, the first one that came out.
But that language doesn't apply to while the application is being considered. And I do believe that there is language in HAMP guidelines that do apply to when the
Yeah.
application.
Right, you're right. There is language that, it's not up there, but there is other language.
There's a section in your handout that's called Select Legal Issues, and cessation of foreclosure is one of the issues. It's paragraph number 5, it's page 8 of the handout. And the language in both the program guidelines and supplemental directive is not as strong as we would like it to be. It's much stronger if the trial period has started than it is when you're just applying for the program. Which is why the foreclosure lawyers feel like they can proceed through default judgment and scheduling a sale. As long as they don't actually hold the sale, they believe they're okay.
So this is the crux of the plan, is how to get that number down to 31%. And that can be a dramatic change, especially if someone's been laid off and they had a very large mortgage that they just can't even come close to. So it's called the waterfall, the series of events the series of steps that they have to take in order to get down to that point. First, they capitalize the outstanding costs and the accrued interest, right? So the fees and costs, the amount that's late gets capitalized, so there's no upfront payment that's required by the plan. A lot of times you'll see this, probably less now than a few months ago when it was newer, but servicers were demanding a contribution upfront. That's not part of the plan. So if you see that, definitely that's not right. Once they've capitalized the fees and costs, they reduce the interest rate to as low as 2%. Until they get to as low as they need to get in order to get it to 31%. That is for just the first 5 years of the plan, after which it will go up to the lesser of the original rate that the loan was at, or the Freddie Mac primary mortgage market survey rate for 30-year fixed rate mortgages. So that's a pretty reasonable rate. So there's no, at the beginning there was a fear that after 5 years it would skyrocket, but that's very unlikely if that rate doesn't dramatically change. But the 13% rate that maybe you had at the beginning, before the modification, that's probably never going to be seen again. But it is the 2%, the really low rate, is only for that first 5 years. If doing that does not get you down to 31%, then the next step is for the servicer to extend the loan up to 480 months, so another 10 years, a 40-year loan from the date of modification, not the date of origination. So that gives them a lot more leverage to get things to the 31%. And if that doesn't work, then there's forbearing the principal. This is an optional step to either make it a non-interest-bearing balloon or, no, that's not optional, to make it a non-interest-bearing balloon, but what's optional is forgiving the principal, the difference. And that is something, I haven't had any cases where the 31% wasn't met with the first two steps, but I doubt there's too much forgiveness going on.
Right, so keep in mind, forbearing principal required, forgiving principal not required. They have to lop off a big chunk of the loan and put it at the end if necessary to get the payment down to 31%.
Are there any questions about that?
Well, if we can climb back up the waterfall for a minute.
Sure.
To stopping the foreclosure. Does anybody in the room is there experience in the room about people being successful in doing that?
Doing what?
Stopping the foreclosure by pleading non-compliance or pleading something about a HAMP.
I got a stay. The other attorney didn't. We had a scheduling issue, and the other attorney wanted to file for summary judgment and wanted to stay. So I filed the hot docs stay document. The court granted the stay with consent without getting into the issues.
I think it's
So
important.
let me ask about that. So it's a petition to stay the foreclosure proceedings wherever it's at.
To stay it generally was before entry of judgment.
And so in your case, the other side had filed a summary judgment motion?
No, they were unable to do that within the court's scheduling deadline. So they were interested in having it
Oh.
stayed. So I said, I'll draft something. So I drafted up a rather extensive motion using the hot docs model So that was educating the other side because they had been quite flip about their signatory, but they hadn't considered a HAMP request.
That's a great use of that. I was thinking of that as only a way to stop a sale, but if you file it during the pendency of the foreclosure to save yourself from having to deal with a summary judgment motion, that seems like a really good use of it.
I hope people will post, if they've been successful in doing that they'll post it on the listservs or let all of us know about it so that we can cite
Yeah.
that in other.
We've filed answers, and we don't yet have summary judgment
Right.
motions that
Right.
will let us know if the judges are
Right.
buying that as a reason for not granting a judgment. We've also filed petitions to set aside sheriff sales, and we've had more success in getting sheriff sales set aside over the last year than in the last 20 years, in my knowledge. Which isn't to say a whole lot of them, but it's always struck me as very hard to do. But this program, I think, gives you a reason to get a sheriff sale set aside if you can get the petition filed before the deed has transferred.
Yeah, on that point, that's the black letter that's in the one of the links that the hot docs motion takes you to directive number 2, where there's express language that says a foreclosure sale should be stayed
Yeah, right,
while the
right,
HAMP
'cause-
request is being considered.
And that's the stage in the foreclosure that these guidelines are the clearest about, that they're not supposed to sell your house while you're applying for him.
Any other questions there?
Does that 31% include like taxes?
It has to include taxes and insurance.
Okay.
So that the 31% has to cover principal and interest, taxes, and insurance. If there wasn't an escrow, and with many, many subprime loans, most, there wasn't, it now needs to include an escrow, and the full payment, including the escrow for taxes and insurance, has to come within that 31%.
Do we know where mortgage insurance fits in to that picture?
It is included in the 31%. If there's private mortgage insurance, and I don't know what happens to private mortgage insurance under HAMP. I haven't encountered that. It does, I don't know if they can continue it. Some private mortgage insurance payments are outrageously high, and I think could end up eating up all of the 31%. So I just haven't seen a case that involved it, so I haven't had to deal with it.
Okay.
Oh,
Sorry.
what happens to that difference, when it goes down to that 31%? Is it tacked on to the end, or, like, when does
Well,
the...
a lot of times there is no difference. If you just lower the interest payment from 10% to 2%, the monthly payment goes well below where the 31%.
And so the borrower doesn't ever have to make up that percentage
No,
difference of
that's
interest?
why it's a modification. You're modifying the terms. But if after doing that and after extending the term to 40 years, there's still some left over, that's when it can be forborne or bared, and then possibly forgiven.
And they don't have to go down as low as 2%. If, they will, I think, go 1/8% to see how low the rate has to go to get to 31%.
Just to be clear, if you go down this waterfall, you try one step. If that works, you stop there, you don't go down any further. And then if that doesn't work, you go down to the next step and see if that works.
Right.
And so you don't even have to, does the borrower have to pay back, say they're behind 5 months, and they modify the loan, but they don't owe the interest that they should have paid for the last 5 months? It's just a modification, and they're going forward with their new rate, or?
I think the interest that has already accrued on that at the old rate, that gets capitalized into the...
Okay.
So you end up with a larger principal balance.
Tacked on.
Not at the end.
Oh.
They capitalize the arrears, the
Okay.
interest, the fees, all becomes part of the new principal balance.
Okay, and then with the new lower interest rate?
Right, and if you lower the interest rate as far as 2%, maybe even with that much higher principal balance, you still get the payment down to within 31% of the gross income. If you don't, then, as Dove said, you go to the next step in the waterfall of extending the term, and then you lop off a chunk of that newly increased principal balance, and that's when you stick it at the end as a balloon.
Now, they're allowed to capitalize attorney's fees, court costs, all that fun stuff, but not late fees. They've got to waive the late fees, which, it's a little tiny bit out of this whole thing, but not everything gets rolled in.
And they can't charge prepayment penalties. If this was a relatively new subprime loan within the 3-year period that was most typical of adding a prepayment penalty on if you refinance, they are not allowed to include that in the new principal balance, in case anybody is cheeky enough to try it.
What if you believe that, what if your client's looking up and they're offering you something, but they've included exorbitant attorney's fees that you believe are improper?
HAMP doesn't require that they waive any legal claims. And any HAMP agreement should not have any provision that waives claims. One way of dealing with that is get the HAMP. And I would wait, in fact, until the modification, the final modification comes, because I'm worried about what's going to happen after the 3 months. But you can have them sign the trial period plan and then bring, say, an Act 6 action to recover for the excessive fees that they've included in it. Because they're not required, the homeowner's not required to waive any legal claims, I think you could still do that. But for any client you got to weigh, this is a decent loan modification. Do you take it and accept the possibility that you're giving them $5,000 more in fees than you think they should? And you got to, I would talk that through with the homeowner and let the homeowner make that decision. In outrageous cases, I would be interested in filing an Act 6 action to recover excessive attorney's fees and costs.
And you can also set it up as a RESPA case if you do a qualified written dispute letter first, and then they refuse to modify it or correct that error, then you've got a RESPA case on top of your Act 6 case. So, you know, you can turn this into a nice fee-generating case.
And we'll talk more about the
Yeah.
Act 6 and RESPA tomorrow.
And then, are there any taxable issues when, by decreasing the interest rate or? anything?
No, the only time that you might run into a tax issue is if they have forgiven principal, which they're not going to do. I mean, the lenders, the servicers just aren't going to do that.
I think one of George Bush's finest acts was that, in, was it December a couple years ago, when they changed the IRS code
Yep.
to forgive this. So I think any modifications that arise out of this are not going to have a
Yeah.
taxable consequence.
That's probably the case.
So I guess I'll pick up the pace a little bit so we have time to go
Yeah,
through
we're-
everything. So at the end of the day, there's a lower monthly payment, a waiver of fees. Borrower can't be charged for the costs associated with this particular program. Like we just said, no waiver of rights. That'll become a bigger issue once the final modification papers come through and they include all those things that you disagree with. But again, there are those actions that you can bring to address that.
Right, by the way, I'm sorry, when you get the trial period plan, you don't know what the principal balance is. The trial period plan form, it's a form agreement that they all have to use. It just tells you the monthly payment. That should be 1/3 of your client's gross income. It doesn't tell you what they're going to do with the principal balance, the interest rate. You don't have any of that information until they've gotten through the 3-month trial period plan, and then they're supposed to send you the final modification.
Can I just say, my understanding is that a lot of these trial periods are actually lasting longer than 3 months, because it's taking longer than that for them to get together to the final thing. And what you need to do is continue making the payments beyond the 3 months until they get around to making the final plan.
That's probably the norm. There's another incentive for borrowers to stay current. They get $1,000 a year in principal balance reduction for the first 5 years of the loan mod, so that's a small benefit. No cash is required up front. That's very important to know that, because often it is requested. Second mortgages I'll touch on really quickly. All other loss mitigation options still apply. Just because they're rejected for that doesn't end the story with respect to foreclosure. All the other stuff that is in your arsenal still exists. And sometimes it's not impossible to get a better deal than HAMP. HAMP's not necessarily, the end all. Well, I think this is probably
For counselors.
Yeah. So let's just forget about that. The other things I want to just touch on really briefly are the second mortgage program and the FHA HAMP. Because we only have, I think, 5 minutes left, I'll just 15?
Let's still be quick.
Oh, I've got 5. So the second mortgage program basically is when you have this, all of this dealt with the first lien mortgage, and then many people have 80-20 situation or any kind of second mortgage. For those second mortgages that are $5,000 or more, there is a second mortgage HAMP program. And basically, you can find those directives through the websites for the program in the handout. But the way that it basically works is that if the first mortgage was modified pursuant to HAMP, and the second mortgage is held by a servicer who is also a participant in HAMP, then that second mortgage is eligible. So sometimes, I'll clarify that, sometimes you have the same servicer servicing the first and second mortgage. Then you still have to check whether the second mortgage is, whether the servicer is signed up for the second mortgage program, because it's a separate program. So you can have a servicer that's participating in the regular HAMP, but not the second mortgage HAMP. And I don't know if you can have the alternative, but it's definitely you have to check. So the first question is the first mortgage modified? And if it is, then look if the servicer of the second mortgage, whether it's the same servicer or a different servicer, is a participant in the second mortgage program. If they are, then that second mortgage, if it's more than $5,000, should be modifiable, and it's done in a similar way to bring the interest rate down to 1% for 5 years, and then after that, link it up to the rate for the HAMP modified mortgage. There's a database that Fannie Mae, who's running the program, uses to link up first and second mortgages, because second mortgage servicers are often not the same one, not the same servicer. So how do they know what's going on with the first mortgage, whether or not it's being serviced? When they sign up for the second mortgage program, they sign up to this loan processing analytics database that links them up. So they'll get notification when the first mortgage has been HAMP modified, and then they have to solicit the information they need to modify the second mortgage. That's one option for the second mortgage plan. The other one is for them to agree to extinguish the mortgage altogether in exchange for a lump sum payment from the Treasury, which is, pennies on the dollar, but they might decide to make that decision. This is a very new program, but all you need to know is if there are two mortgages, see if the first mortgage is HAMP modified, and if it is, then check if the second mortgage servicer is a participant in the second mortgage HAMP program. And the other thing to touch on is the FHA HAMP program. That is also similar in that it uses a waterfall, but it's different in that it allows for a partial claim, which is basically 30% of the principal can be forgiven or wiped out altogether. And it's a little bit complicated to go over in a minute, but it's not forgiven. It's a non-interest-bearing balloon at the end of the mortgage, and it's in your papers there. It's in the mortgagee letter. I think it's dated July 30th. It's 2009-23. You'll see it when you go through. It's in smaller print. There's an example that's definitely worth going over. This is from the Treasury Department. It's a very standard example, and it shows exactly how it works. Basically, up to a third of the principal can be put into a non-interest-bearing balloon at the end of the mortgage, and that can be pretty significant. So that's also very new. I don't have any experience with either of those latter two programs, but the important thing to know is that they exist. If you encounter second mortgages or FHA loans, just look it up or look into these documents, and you'll see how it's done.
And you know what, I know we're running out of time, and Jennifer has some things she wants to share with you, but I think that we didn't talk about the net present value test under HAMP.
Right.
But just be aware there is a legitimate reason that a servicer can say, no, you don't get a HAMP modification. Because this program is trying to be consistent with the best interests of the mortgage owners along with the best interest of the homeowners, the mortgage companies will do a calculation, and they'll be doing it while your homeowner client is in the trial period plan. They're going to calculate whether or not they're going to make more money by taking the house or more money by accepting the stream of payments under the modified loan. And if their calculation comes out, you get more money by taking the house, they can proceed with the foreclosure, not give the HAMP modification. there are lots of factors. The net present value test is the name that they've given to this calculation. And it's a bit of a black box. In fact, it may even be proprietary, that the mortgage servicer doesn't have to give us the exact details of how they calculated it, and even if they did, I wouldn't understand it, because it's probably very complicated. But the key factors are the amount of equity in the house. If the house is worth a lot more than the mortgage debt, especially if the homeowner has a very low income, such that 31% of that income is pretty low compared to the value in the house, the equity in the house, they're likely to be turned down. The net present value test is likely to come out against modification. So keep that in mind. But that's the real reason that they should be giving you, if they're saying no, that you failed the net present value test, and then ask about the details. If you think that they overvalued the house, find out the valuation they put on the house. In Philadelphia, there's a whole lot of variety within just a few blocks, and if you believe that your client's home is worth significantly less than they do, you can get an appraisal and challenge what they used in the net present value test. So keep that in mind. Them saying no doesn't have to be the end of the story. You can ask in discovery or in a RESPA request for the details of their net present value test, and just keep pushing at that issue.
Conceptually, that's the biggest weakness in the plan, is that there is this way that they can say that you're rejected. And based on what Beth was saying, if someone has almost paid off all of their mortgage and they have a lot of equity, well then in the calculus there doesn't remain that much money to be gotten out of the homeowner. And if they go to sheriff's sale, they'll get to keep all the proceeds of the sale. So the more money the homeowner has in the house, the less incentive there is to give a modification, which is kind of definitely a negative aspect.
Okay, am I up?
Yep.
All right. So as I mentioned earlier, there's this companion program to HAMP, which is called HARP, which is refinancing. It is designed for people who are not defaulted on their loans. So they need to be current on their payments, and it's for loans that are held by Fannie Mae or Freddie Mac. How do you know if your loan is one of those loans? Those are the websites that are part of this this one-page handout. It's the first page in the big packet, and it's titled Preserving Homes in Hard Times. If you have the smaller packets, it's the individual page, and it's got the same title as the presentation. But they're practically the same information. And the addresses to figure out if it's a Fannie or Freddie loan are right there. You can refinance up to 105% of the value of the house. So if you're a little bit underwater, you're okay. You can refinance the first mortgage only under this program. We're not I don't believe that there's any companion refinance for second, but you could still use those other programs that Dovie talked about for the second mortgages, including the extinguishment program. So you could work on that. You could just keep the second mortgage if they agree to remain in second place. You could just refinance the first mortgage. The goal of HARP is to get people out of these exploding arm loans and get them into a fixed rate loan at market rate. And so it gets determined at the time they make the loan. It's fixed. It's a 30-year mortgage. It's designed to keep people from getting into trouble through these exploding arms. And I now would like to move on to talk about some of the state programs. And the principal program is HEMAP. And just by a show of hands, how many people have done work with HEMAP or are familiar with the program? Okay, so we've got a good group of people who have some familiarity. For those of you who don't know about HEMAP, HEMAP is a loan program that's run by the state of Pennsylvania. It's run through PHFA, and what it does is the state will actually give homeowners money to get caught up when they fall behind on their mortgage. And in some instances, they'll even do a continuing grant or continuing loan where they will continue to help the homeowner pay their mortgage until they get back on their feet. And under the provisions, the standard time period that they'll help people is up to 24 months. But that's changed because of our economic crisis. And that's where I wanted to focus a lot of the updates that we have for this year. There is a high unemployment provision in HEMAP. So when unemployment raises above 6.5% for the state, these provisions kick in. And we've been there for over 6 months, and we're probably going to be there for many months to come, which is bad for our state generally, but it's beneficial for this program. because under this now, instead of 24 months, we get 36 months. And that doesn't just, it's if your client is delinquent up to 36 months, they still have the right to receive the Act 91 notice before they can go to foreclosure. They also can now argue before the HEMAP appeal, or if they've gotten denied, they could say, look, I have up to 36 months to be able to resume my payments. I'm going to be able to resume my payments, but now you can show that there's a longer period in which they're going to be able to get to that status. The other benefits when you hit this this threshold is that the test for repayment changes. The repayment kicks in when there is a threshold where their income is more than, where their housing expenses are less than typically 40% of their total income, but now that threshold's been reduced to 35%, which means they can remain in their non-repayment status, where they only pay the $25, they can remain there longer because of this new threshold. Additionally, when they do go into repayment, the amount they repay has now been changed from 40% down to 35%. So when they do get into repayment status, they have to pay less as long as the state remains in this high unemployment status. The other things that have changed with HEMAP in the last year is September of last year, the laws have changed to clarify some of the things I think most of us already knew about HEMAP. Now, when you get the Act 91 notice, the person has 33 days from the date of mailing to get to a housing counselor for their face-to-face meeting. It used to say 30 days. There's now been clarification that there is an extra 3 days for the time to mail it. So it's 33 days to get to the counselor. Another trick that I've always used, they do not have to submit their application in that 33 days. That is not the test. The test is that they have to have a face-to-face meeting with a counselor in that 33-day period. The counselor, at the time of that meeting, faxes a notification of face-to-face meeting. It's called Appendix B. It's in their forms that they use. And they fax that directly to the mortgage company. By sending that notice, the mortgage company has to wait another 30 days before they're allowed to file a foreclosure action. So really, from the time of mailing of the Act 91 notice until the time the HEMAP application has to be submitted, you can get that extended up to 60 days. And I sometimes will coordinate with the housing counselor and have them schedule the appointment for day 32 and say, can you please not submit the application until day 29, because I need to get more time for this client to get them on the right track. And if you can get a cooperating counselor who's willing to do that, it's completely legitimate. It's the way the program works, and you're meeting the deadlines. The trick is you got to make sure you have a counselor who's good about following the calendar so that they don't miss the deadlines. And I generally do the reminding if I'm going to play close to the deadlines like that. And once the application is submitted, PHFA has 60 days to decide it. So you could really get up to 120 days before you have a foreclosure filed if you're looking at a HEMAP denial. If they're accepted for HEMAP, obviously it prevents any foreclosure from happening. A couple of areas that HEMAP is really good for. I know I personally have some frustrations with HEMAP because I have people that I think are really good candidates and they get rejected. It's not clear why. But some of the patterns that I've seen and the reasons I like HEMAP is more understanding than mortgage companies about the missing spouse problem or the missing homeowner, the missing co-owner problem. Mortgage companies, when you try to get these modifications, often demand we need all the parties to sign. HEMAP, if you explain that you have no control over this person, we don't know where they are, they'll sometimes look past that and not worry about that issue, and they'll still grant the loan. The other issues that have been clarified in this new era since last year, you can apply late. So if they get that Act 91 notice and it's day 34 when they come to your office, all they have lost is the stay. But they can still apply for HEMAP. They are still eligible for HEMAP, and they shouldn't be getting denials that say you applied late. In the old days, I used to get those letters with those denial explanations, but that's no longer legitimate. And if you get that, please let me know, because I'd like to know why they're breaking the rule. They also, you can also apply if there's a change in circumstance. So, for instance, if somebody was denied before this rules changed in September of last year, you could now try reapplying on the basis of the time periods have changed. So now you need to reevaluate whether or not they have a reasonable prospect to resume. And so you can use, if you think that they have a good chance of being accepted, this might be another reason to reapply. The people that I've seen that PHFA really likes to give HEMAP loans to are people who've already gotten their new income stream, because that to them is the most obvious reason that they're going to be able to resume their payments. It's not the way the program was designed in my mind. I think that the program was designed to help people during a period of unemployment. It's difficult to convince certain reviewers or our loan reviewers of that, especially when their budget is tighter. They also really like what I call the little old lady application. I've seen situations where I thought there's no way this person's going to be accepted, but they've been accepted because there might only be a year or two left on the loan completely, and they don't want this person to lose their home, and they might even make it a loan they don't have to repay. I've seen very odd things like that happen. So if you have a scenario where you have a very sympathetic person and it's not going to cost that much money to fix the problem, you might think about HEMAP even if it doesn't fit the other natural boundaries of a HEMAP application. How am I going to time? Am I over? Okay.
Yeah.
To touch on very briefly the other programs, HERO, it's run by PHFA. It's designed to get people out of predatory loans. It doesn't seem to work really well, and I won't say any more than that. REAL, it's kind of a companion program that seems to, that kind of mirrors the HARP, where you have to have a person who's already, able to get a loan through the regular channels. So it's for people who have these potentially exploding loans who have good credit. Two other issues I want to remind you of. Countrywide settlement. Pennsylvania is part of that countrywide settlement that got a lot of press. That is designed to modify loans down to 35% of a person's income. HAMP is a little better, but if you get denied for HAMP, and it's a countrywide loan, go for Countrywide. Countrywide doesn't exist anymore. They're Bank of America. So if you have a Bank of America loan, check and see if it used to be a Countrywide loan, just in case.
Details about the countrywide
Yes.
settlement are in your packet if you have the big packet. If you have the little packet, it's on the disc that came with your conference materials.
And then just the rest of the other private lenders, they do have loan modification programs. It really is worth pushing them to try because once they get you in a track, they forget to get you in the other tracks. And they're very compartmentalized in the way they think about solving these problems. So you really want to try and advocate to make sure that your client's being considered for all the options available in that lender's loss mitigation.
Do check out the materials on the disc if you have a chance to. There's some good information lender by lender on programs that they have or had beforehand. The handout includes legal issues related to HAMP. We've gone through and cited the places in the supplemental directive and the program guidelines where there are references to different issues that may come up that you want to push back on. So do look at the materials. We're done.